Welcome to another edition of Real World Business Law, where we discuss real-world legal issues. Today, we've got a great topic that we'll be discussing. I'm Declan Leonard. I'm managing partner here at Berenzweig Leonard. I'm here with my co-managing partner, Seth Berenzweig, fresh off of the set of Neil Cavuto on Fox Business. You had a great hit just now. It's amazing. You were on at 1:50, and we're doing this about an hour. No, we're doing this about 40 minutes later here at the thing. So I hope you're not too tired.
No traffic, no problem.
There you go. That's one benefit, I guess, if you want to say that, of COVID, is that in the D.C. area, traffic has been pretty light for a long time here.
Clean sailing.
Well, listen, so we've got a really good one today. We've got sort of a Goliath versus a Goliath. We've got Google and the government. The government sued Google last night. Why did the government pick on my Google?
Well, I know. How dare they?
That's right.
Yeah.
Google. Sorry.
The Google, exactly. Well, the federal government, specifically the Department of Justice and 11 states, filed basically what is a landmark case late yesterday in the federal district court here in Washington, alleging a violation of the Antitrust Act, claiming that based upon their search services and their search sales, that Google is operating essentially as a monopoly and violating the Sherman Antitrust Act.
So monopoly, wow, we haven't heard that in a couple of decades, really. I mean, you hear it every once in a while, but back in the Microsoft case,
that's right,
in the late 1990s with Bill Gates and being deposed, and the word back then was thrown around a lot: bullying tactics, things of that nature. Do we have similarities with this new Google lawsuit?
Well, the allegations are really trying to lean in that direction. Whether or not they did so persuasively and successfully is yet to be seen. It was a very different world back in the 90s. And of course, there really was a long saga that went through with the Microsoft case. There was a victory for the government in the trial court.
In the
Microsoft case, there was a partial victory in the appellate court. And then when it got remanded, there was a lot of drama. And ultimately, it resulted in a settlement. And a lot of people are saying, why did you have to go through all of that time and expense? I think those are similar questions that will come here. To answer your question, there are some allegations of alleged bare-knuckle, sharp elbow tactics, trying to eliminate competition, getting tie-in and exclusivity agreements, trying to lock other people out to create barriers. But in the complaint, there are also allegations that recognize that there are a way around those barriers. So in the 60-page complaint, on paragraph 47, it acknowledges that if people don't want the default Google setting on their iPhone, well, they can just go ahead and get something else.
Yeah, I heard some testimony from somebody from Google, and I know that it was even referenced in the lawsuit. It basically says, the government acknowledges that unlike back when we had Microsoft, where it was really tough to, you had to put a separate software on to dismantle what they were presetting or preloading onto their program. Here, it really only just takes going through either your computer or your phone and changing your search engine. So it's. But they cited this in the lawsuit. They basically said, yeah, it's easy to do, but studies show that most people don't do it.
Well, so, guess why?
They
because
do
they like Google.
Yeah, that's exactly right. I mean, I found it ironic as I was prepping for this podcast. What did I do?
You went on Google.
I went on Google.
Of course. Yeah, if you wanted to find out what's up with the Google case, what search engine did you use? Bing?
And it didn't repress anything. It didn't say Google has not been sued and it's all fake news. It told me what I needed to know for purposes of today.
According to the complaint, and these stats are probably without dispute, the total search market held by Google is over 80%. The total search market held by Bing is somewhere between 6 and 9%. And I think that if you look back in terms of the technology and see how the market forces have been acting, if you take a look in the Microsoft period when that litigation was happening, and in the late 90s, you would have companies like MySpace and AOL that were the behemoths then, and these companies that we're talking about, such as Google, were really just in the crib, so to speak, and the market took care of that. So now the feds are trying to take care of it.
Yeah, at one point, Yahoo, which is a competitor of Google, at one point Yahoo had, I think, 30% of the market, and Google had 35%. Why is this just not a case of Google having built the better mousetrap? Like, why is it that they just scaled better? They knew what to put into place. They were just better business people. And history in the last 2 decades is full of companies that we thought were behemoths, that were monopolies. And where are they today?
Well, that's exactly right. And you let the free market work, and then let's see where where they're going to be 10 years from now. The application of YouTube in the context of 2020 is going to be markedly different in 2030. But the other thing that I find interesting is when you talk about the passage of time, the legal vehicle through which this case is being driven, as I mentioned on Fox earlier today, is really the equivalent of an old horse and buggy. This was a statute that was created in 1890. Well, we didn't have Google on our cell phones in 1890. We didn't really have much technology. Now, fast forward over today. Congress has all these opportunities to make all these positive changes. And just weeks ago here in Washington, they had this hearing where they had all of these major top 4 tech CEOs in. And instead of going through and talking about how to make antitrust better, how to make antitrust more contemporary, how to deal with other things such as data privacy and data security, what do? The Republicans say that they're throwing out the flag, saying that Trump's a victim of selective editorialism, and the Democrats are coming in saying that they want to sledgehammer success. That's not the way the market works.
Yeah, and you mentioned cell phones, and that's really what this is about at the end of the day.
Sure.
I mean, obviously people do searches on their laptops and they do searches on their mainframe computers on their desk, whatever, they're standalone. But it's really about cell phones because studies show that most people are doing searches on their cell phones. Most searches are going out. And apparently, from what the lawsuit says, Google captures about 95% of those searches done on cell phones. Now, Google comes back and says, yeah, about 50% of the searches are actually related to people shopping on Amazon. So, you know, why isn't Amazon next? And who knows? Maybe at the end of the day, you know, this is maybe the start and not the end of what the government intends to go after.
Well, I think antitrust certainly should be updated, and it hasn't been updated in a very, very long time. I think that you can look at the situation from an acquisition perspective without trying to obliterate and punish and neuter these very successful companies, and then maybe apply a different standard within the IT space going forward. But I think that the government should be looking more at wealth creation rather than wealth destruction. The government, in different contexts in the market, can be very effective when it wants to in terms of awarding small business success. In the government contract space, there are affirmative small business plans and government contract awards that are set-asides, and there are tax breaks. Why can't Congress come up with a more creative solution for creation rather than destruction?
That's right. That's right. And ultimately, these laws that Congress, as you aptly noted, are really should be updating. These laws are not there necessarily to repress businesses from growing. They're there to protect ordinary citizens. And so, you know, as you look through this complaint, what is it that you think that the government will be able to prove, or at least what will they point to say, you know, with Google around and controlling so much of the marketplace, that it is harming consumers?
Well, they'll definitely be able to establish market dominance. They'll have a relevant marketplace. They'll have market dominance of that relevant marketplace within the United States. But that's where I think the gas runs out of the car, or in this case, the horse stops pulling the horse and buggy.
Yes.
Because they really don't have any demonstration in the 60-page complaint that there has been one stated instance of price control, price manipulation, price inflation. The whole essence and the whole underlying purpose of the antitrust laws is to protect the consumer. Yes. I thought that what the government was going to do, and I thought it would have been effective, but they pretty much failed to do it to a 99% degree, is to say if you go into the ad billboard marketplace within the tunnel of the Google ad space, that they should be able to demonstrate increased prices for the buyers and sellers of advertising space through the Google channel, because they're holding the supply and the demand, where they ultimately end up negotiating with themselves. They didn't even go through one pricing mechanism or example on that.
Price manipulation, all of that would be an example of unfair competition, crossing the line. In fact, you know, it's interesting. One of their paragraphs in the complaint said they thought that this was relevant, that Google is so omnipresent that it's not only a noun, but now it's a verb. They took a whole paragraph to say that. And it's like, okay, so what? You know,
that's success.
Kleenex is one of these words that indicates any kind of tissue paper.
Sure.
You know, so that alone would not be dispositive. They talk a lot about bullying tactics.
Right.
But you know, the question is what, and I think this is what the case is going to be really all about. What constitutes good business, aggressive but good business practices that enable you to scale your business versus crossing the line, things that you talked about, price manipulation. If they were manipulating searches, and again, there is allegations that there are search manipulations going out there. That's not what this case, as I see it, is about.
Well, that's right. And the question is whether there's something that could be characterized, for example, as predatory. There's nothing even close to that. So if you go back in a very closely related hearing with the Antitrust Subcommittee in Congress, when the hearing that occurred a couple of weeks ago, they were giving examples with Jeff Bezos where Amazon has an algorithm that presets a favor for Amazon products. You know, that to me falls under the category of it is what it is. It's not predatory. It's not illegal. It's not, and as far as the consumers are concerned, it provides better pricing and better options, not worse pricing in a more restrictive marketplace.
That's right. I mean, the Amazon example, exactly. The marketplace is filled with vendors who will claim, oh my gosh, my margins are being slashed and everything. But they are going into this saying we have this whole marketplace. The same with Google. I mean, when you go on there, you know when you do a search that you're probably going to get the most comprehensive answer. I mean, you're probably going to get the most comprehensive material. They don't charge you for that last time I checked.
Well,
they don't charge you for that.
That's right.
They make all of their money, or pretty much all of their money, off their digital advertising.
Exactly.
And maybe there are instances within the digital advertising that maybe they could have looked into more. But I think this one really is, you're really big. It's hard for competitors to come in and compete with you. And, you know, I was thinking about this. Well, sure, you're not going to beat Google at its own game. It captures all of the searches. It's very efficient. Its algorithm, I don't understand it, but apparently it's very well, respected. It's pretty intricate. But a company could come along and say, you know what, Google, you really don't do one thing well, you don't do privacy well. And so ours is going to be privacy. And you know what? You would capture a lot of consumers. You might not make as much money as Google, but you'd have your niche.
Well, remember a little company called Cambridge Analytica? I mean, there's so many opportunities with big tech and with the companies, including Google, that were in front of the subcommittee in Congress. There's lots of opportunity for companies to come in. At the end of the day, I think that one of the aspects that's going to be very interesting and ironic about this case is that Google isn't really the only entity on trial. I think the government's on trial. The government's on trial because they're going to have to own up to the fact that the FTC and the prior administration went for years looking at Google from an antitrust standpoint. They did nothing. Now they're going in on an antiquated statute from 1890. They're going to try to do it again. If this is going to end up anywhere close to Microsoft, it's just going to go around and around, and they're not going to sink the hoops. So
it's not like Microsoft went away. Last time I checked, Bill Gates is not living, in a shack down by the river. I mean, he is. They've obviously prospered.
That's right.
And you know what? Maybe they curtailed some of their business behavior and practices. I think they've still been very aggressive in their growth over the last 2 decades since that case. And I think the same thing with Google. You know, you and I were talking off camera about the prayer for relief, which is the legal word for what is it that the government's looking to get out of this lawsuit. And it's incredibly generic, isn't it?
It's amazing. It's almost like the guy who, or the woman who walked in that day to write the end, left for breakfast and failed to come back. There's nothing in there. It's basically find that they are violating antitrust law and any other relief that the court deems proper.
Not looking to shut them down. I mean,
not even break them up. They didn't even say what they wanted. Can you imagine our law firm filing a brief, going through all of the the trial and the dramatics and the parade of horribles
and everything.
And just say we would just like a finding and Judge, whatever else you think is
make
good,
it right.
Just it's like someone used to tell me at a firm I used to work with. There's nothing in federal law that's called "do the right thing" statute. There are specific remedies, and when the Justice Department can't even come in and say what it wants, I think that just shows how much of a clueless uphill battle this is going to be.
I think we saw there was a rough battle, obviously, a couple decades ago with Microsoft. Ultimately, it resulted in a settlement, and the company continued on. I suspect, based on what we just talked about, the very sort of generic prayer prayer for relief, what the government's looking for, that this may end up going the same way. They'll get their public, ounce of whatever you call it, and
ounce of digital flesh.
Ounce of digital flesh, exactly. And then what will ultimately happen is, Google will agree to perhaps curtail some of its stuff, maybe whatever that looks like at the end of the day,
softening out
and
the
then
edges.
they'll go on.
I totally agree. I think that prediction is spot on.
Yeah, great discussion. I suspect we'll be talking about other tech targets coming down the line. But again, thanks everyone for joining us for this edition of Real World Business Law, and we look forward to the next one. Thank you.